Thanks for being here. This is true crime and celebrity news. If true crime and live court trials and short videos your thing, with some celebrity news thrown in, please consider subscribing to my channel and also don't forget to hit the like button. If you enjoy the content, please check and make sure the notification bell is on. Have a wonderful day and see you in the next live.
Good afternoon, true crime friends. How are we doing on this fine Monday? Today is day 6 of Kouri Richins, and I'm not sure of the lineup. I haven't really even looked. Sometimes I take some sneak peeks, but I haven't done that today. Also, before I forget, don't forget to like, share, and subscribe. This is live court. I'm giving live commentary for fair use, and trying to think what I had wrote down for Mr. I think I read it all already. I think I read all my notes that I wrote down with the rest of Carmen. Then there was the Isabel, and then there was Robbie, and then the drug enforcement guy, and then I think that's where they called it quits for the day. I think there wasn't much. I had to go over to court TV to get the rest of it, so that was kind of confusing. So good thing I did So we're on day 6. I guess I need to get my notes together. But I'm pretty sure go over the main components of everybody. You've got Kouri Richins. You got Carmen Lauber. You got Robbie. You got Nicole. And Nikki. Yeah, Nikki. And Eric's sister, brother-in-law. We had the medical examiner, her assistant. So we're getting along pretty good so far in this case. And things that I wrote down are things that Carmen had went back on. Like, she said that Kouri allegedly picked up the ills in her driveway the next morning. Kouri wanted the Michael Jackson rug. Kouri, in fact, has public defenders not being paid for. They were given to her by the state. And the Midway house was sold in 2022, January. So some things weren't quite lining up. And the defense attorney was catching on to it. They all had grants of immunity. Robbie and Carmen. Robbie had only met Carmen twice. They met at I misspoke yesterday. Mavericks is a gas station. And he said there were 30 to 40 of the Roxys. He said that he's pretty sure he did not sell the fentanyl because back then nobody was buying it because everybody was scared that they were going to get the fentanyl. And I heard through the grapevine that allegedly the narcotics officer said that that was not true. People were buying it up, but how many of those people did not make it is the question. So that's about it. So we start a new day and get carpal tunnel today. All right, let's get this started. Thank you so much for being here. Please don't forget to like, share, and subscribe.
His testimony, and I will let them make.
Counsel, tell me more.
Judge, it is simply that we have not been able to consult with Dr. Christensen. We have reached out to him we have not been able to consult with Mr. Christensen or Dr. Christensen. We've reached out numerous times. Got on the phone with him once. He was unavailable. Asked me to get time with him. That was about 4 or 5 weeks ago. And haven't heard anything. Last week we informed the state that we haven't been able to get in touch with him. Asked the state to have him reach out to us. He has not
Can you hear me?
reached out to us, so just based on just the rule, and he should be available to cooperatively consult with us. He did not.
I appreciate that. He's here now.
I understand. I think
Mr. Burmester, if we flip the order of events, can we allow Dr. Christensen to consult with defense counsel since he's physically present, and then we can use the time for a different witness?
I have no objection to that. Indeed, I asked counsel time, 15 minutes ago, that's what time that's not. So,
Who else do you have on deck?
I don't know.
Your Honor, let me see. I don't know if we have anybody in until 9, but we'll see.
Okay.
Your Honor, we have an objection to another witness that the state intends to call today.
Let's do it all.
Okay, but let's stay focused on this one for the moment. Mr. Ramos, make a record for me. If I change the order of witnesses and just order Dr. Christensen to consult with you since he's physically present, anything further on that?
Just assuming that we can take that break. I'm not sure who's next and whether it's my witness or not.
Understood. Okay.
Absent that, I will make do. Obviously, I didn't want to do that rushed before we got here. So if we can have an hour or whatever we need,
Right.
That'd be great.
Let's figure out what the order of witnesses is going to be.
May I just have the benefit of the record for
Sure.
like 1 minute? So I spoke to Mr. Christensen or Dr. Christensen this morning. He says that he received a call several months ago from Mr. Bertram saying, hey, we need to set up a time. He never heard from them again. He received a call warning that he would be getting an email maybe a month ago or so. No, a subpoena. He subsequently received it by email. And then he received a call with no message this over the weekend. And that's where we are.
We are where we are. We'll work it out. Mr. Bullardroth, talk to me about the other witnesses that are proposed for today.
Your Honor, I think that other witness is going to draw a motion.
Oh, who is it?
His name is Todd Davis. I guess, I don't know.
Detective.
Todd Davis. Your Honor, Mr. Davis was not on the state's witness list. They added him on Thursday, which I believe is in violation of Rule 16. And I would point the court to State versus Draper at 378 P. 3rd, 1261. In that case, the state had the manager of the store that was the victim of the theft on the witness list. And then later during trial added the assistant manager, and the Court of Appeals found it was an abuse of discretion for the trial court to allow that witness to testify without sufficient notice under Rule 16.
What was the amount of notice in that case?
I don't think it said exactly if it was during trial. It said it was during trial that they announced that she was going to testify. And I don't recall if it was the same day, but I mean, the state's had months and months. We've had 8 amended witness lists, and I think to continue to add witnesses during trial is not sufficient under the rule.
Help me out, Mr. Bloodworth. What is is it Detective Davis?
It's Lieutenant Detective.
Okay.
Lieutenant Davis, right?
Sure.
He, Your Honor, the state is calling him to authenticate the May 4th, 2023 interview video of Robert Crozier in rebuttal to Robert Crozier's testimony. All he's going to do is authenticate the video.
Is that
That's the first I've heard that that's all he's going to do, but
is that issue in dispute? I mean, you reserve your arguments about whether there are other bases to bar the admission of that video,
which I believe there are.
but authenticity probably isn't one of them. Do we really need to call a witness, or can we just stipulate that it's authentic and then the parties will reserve their arguments regarding admissibility?
I would agree it's authentic, but yes, we would have other objections.
So can we just have a clear stipulation on the record that the May 4, 2023 video recording of law enforcement's interview with Robert Crozier is authentic?
Yes.
Your Honor, may I add to that the transcript of the video as well?
Is it a certified
It
transcript?
is certified.
I think that follows from the rule regarding certified transcripts. Ms. Lewis, do you agree?
I agree.
Okay. So it sounds like we don't need that guy.
Correct, Your Honor. We may as well use this time to litigate, I guess, what other objections to admissibility the defense has on the video.
Forgive me, the state is offering the video under which rule or exception?
Your Honor, 801, it'll be D1A, and perhaps some of it'll be D1B. The defense's cross-examination of Mr. Crozier elicited testimony that and the state's direct examination elicited testimony from Mr. Crozier that was inconsistent with his testimony in the video. The defense's cross-examination elicited testimony that he was kind of out of it because of withdrawal and pressure to say certain things. And the video, rebuts that testimony. The video itself is, I think, 13 minutes long. And from the state's view, the entire 13 minutes, pieces of those 13 minutes are direct impeachment, but the entire 13 minutes goes to whether or not he was high and out of it, and whether or not he was pressured into saying certain things. That those pieces of evidence were throughout the entire 13 minutes.
The impeachment pieces, or the more specifically, the D1A inconsistent pieces, those would be, I think, fairly perceived off a cold transcript. The second piece, I'm not sure I or defense or you or the jury would be able to evaluate whether he was in a bad way from the transcript. Is the state seeking to admit both, or publish the video and admit the transcript? What's the scope here?
Your Honor, publish both. We have the transcript running real time beneath the video.
Okay.
So that the jury can watch, listen, and read all at once.
All right. Ms. Lewis, do you have the video with the transcript?
I don't have them together where it
Okay.
shows it under. No, I have them separately.
Right.
I would
Sitting
like
here today, are you prepared to make a record regarding this, or do you need a moment to go through the pieces of, or to make argument regarding certain pieces of the transcript versus other pieces?
I think I would need a moment. I would like to see the video with the transcript
Sure.
run under it, and then, yes, I would need a moment. I would need some time to look at that.
Okay. We'll need to play this out a little bit. The state makes a facially, if not valid, at least thought-provoking argument under D1A, 801 D1A, that the video and the transcript related to it are categorically not hearsay. But having not seen the whole 13-minute video or read the whole transcript, and without the defense having the same opportunity, I can't make a ruling sitting here at the moment. So can we provide the video with the running transcript to the defense?
We can, Your Honor. I believe we placed it in box yesterday, but we can, if they want to, perhaps we can go into a conference room here and we can just play it off of one of our machines.
Sure. I mean, I would also understand if the defense said, hey, we just need an evening with it to go through it, collect our thoughts, have you make a ruling. Ms. Lewis, what's your request?
Depends on what is happening here next. I may be able to watch it now. I don't know where we're headed.
That's the thing, Your Honor. Those were our first two. That was our batter in the box and our on deck batter.
Okay.
So we are scrambling to get our in the hole batter here.
No, that's fine. These things happen. We're going to let Mr. Ramos continue to consult with Dr. Christensen. Ms. Lewis, Ms. Nestor, if you would have a conversation with the state about the video with the running transcript, let me know where we end up.
All right. Thank you.
Okay. Before we take a break for that, Mr. Bloodworth, anything else on the record?
No, Your Honor. Thank you.
Ms. Lewis?
No, Your Honor.
All right. Let me know when you're ready for me. Thank you. Court will be in recess.
Hey everyone, I'm sorry. I'm going to have to end the live. I have a personal issue that's going on right now. I will come back later, okay? Thank you so much for being here. I'm so sorry. So sorry.